A brand new ruling from the United States Supreme Court, with all 9 justices in agreement, is making serious waves in the legal fight over so-called assault weapon bans at the state level. While the case itself didn't revolve around rifles, the way the court laid out its opinion might trigger a major shift in how gun rights are interpreted moving forward. In this breakdown, we're going to unpack how this decision intersects with California's rifle laws, why it matters for Second Amendment supporters, and what we might expect next in this ongoing legal battle for our freedoms. For quite a while now, states like California have pushed laws banning certain semi-automatic rifles, not because of how they function mechanically, but based on purely cosmetic features. Throw a pistol grip, a flash hider, or a telescoping stock on a rifle, and it's suddenly labeled an assault weapon, even though it works no differently than a featureless model. These laws don't target criminals. They go after law-abiding folks like us, regular shooters, who follow the rules. And that raises the core legal question. Do laws based on appearance, rather than function, violate the protections of the Second Amendment? Thanks to both recent legal precedents and a long-standing understanding of our gun rights, the answer is becoming clearer. Now, with this new ruling from the High Court, momentum may be tilting even more in favor of gun owners. Let's zoom in on a case that's been making noise out. Wes Miller versus Bonta. This challenge takes aim at California's ban on rifles, with certain add-ons, things like adjustable buttstocks, vertical grips, and flash suppressors. If your rifle has any of those common parts, California deems it illegal. The case first landed before Judge Roger Benitez, a federal district court judge who ruled in favor of gun owners. His decision was straightforward and firm. California's restrictions violate the Second Amendment. He leaned heavily on previous rulings, like District of Columbia versus Heller and New York State Rifle, and Pistol Association versus Bruin. According to those decisions, if a firearm is commonly owned and used for lawful reasons, the government has no constitutional authority to ban it. But California didn't take that ruling lying down. They appealed to the Ninth Circuit Court of Appeals, and from there, the case was essentially placed on hold. Like many other lawsuits related to firearms, Miller versus Bonta was paused while courts waited on another case, Duncan versus Bonta, which challenged California's restriction on so-called high-capacity magazines. After California won in the Duncan case, the Miller case was moved back onto the docket. Now, both sides have submitted their arguments, and it's up to the Ninth Circuit to decide, will they respect Supreme Court precedent or double down against it? Here's where it gets interesting. In an unrelated case, Smith and Wesson versus Mexico, the Supreme Court unanimously ruled that American gun makers cannot be sued in U.S. courts for crimes committed in Mexico with their firearms. On the surface, this case had nothing to do with the Second Amendment. But during their written opinion, the justices referred to rifles, like the AR-15, as being commonly owned and lawfully used by responsible Americans. That line may seem casual, but legally, it packs a punch. Why? Because under both Heller and Bruin, any firearm that is widely possessed and legally used is protected by the Second Amendment. That simple sentence in the court's opinion may have just cracked the door open to strike down assault weapon bans from coast to coast. What really makes this significant is the fact that this wasn't a narrow 5-4 decision. It was a unanimous 9-0 call. Every justice on the bench, from the most conservative to the most progressive, signed on. That kind of agreement gives the court's language real power. Even though this wasn't technically a Second Amendment case, the way the court described rifles, like the AR-15, builds on what they've already said in previous rulings. And now, that very wording is being used as a major argument in Miller versus Bonta. The plaintiffs in the case are pointing directly to Smith and Wesson versus Mexico, saying it confirms that rifles commonly used by civilians like the AR-15 fall under constitutional protection. They argue that this isn't just an opinion, it's now legal precedent. Whether the lower courts will accept that argument remains to be seen. But one thing is for sure, this ruling gave Second Amendment supporters a powerful new weapon in the courtroom, and it couldn't have come at a more critical moment. So how exactly are attorneys using the Supreme Court's own words to push back against bans like California's? It all boils down to one central constitutional standard, common use. Going all the way back to District of Columbia versus Heller, the High Court said government can't outlaw firearms that are widely owned by law-abiding Americans for legitimate purposes like home defense. That principle was reaffirmed in Bruin, and now it's been echoed again in Smith and Wesson. The legal team behind Miller versus Bonta is leaning hard on that foundation. Their argument is straightforward. If rifles like the AR-15 are in widespread, lawful use, then California's ban simply can't hold up under constitutional scrutiny. Period. This isn't a side-angle approach. They're taking direct aim at the law itself. California can't pretend that AR-style rifles are dangerous and unusual when the Supreme Court just called them commonly owned and widely legal. That matters because only firearms falling under the dangerous and unusual category are outside the Second Amendment's protection. And with millions of these rifles in circulation, used regularly for training, home defense, hunting, and sports shooting, the common use test is not up for debate. This isn't just some abstract legal theory either. Courts, especially appellate courts, don't like going against a rock-solid Supreme Court ruling, especially when it's unanimous. Once the highest court lays down a clear precedent, every lower court is expected to follow. That's what makes this such a powerful strategy. Gun rights lawyers aren't trying to reinvent the wheel. They're just insisting that the courts stick to what the Supreme Court already said. So even though Smith & Wesson started as a case about foreign liability for gun makers, it's turned into something much bigger. It's a legal pry bar, and every time it's cited, it makes it harder and harder for states to justify laws that ban common firearms. Now let's turn to what's happening in the Ninth Circuit, because it's not all smooth sailing. The recent oral arguments in Miller versus Bonta revealed something that's both frustrating and deeply concerning. Not every judge is interested in following Supreme Court precedent. Some appeared flat-out dismissive. During the January hearing, several judges misrepresented the AR-15 platform. One even called it a machine gun. Another referred to it as an A-15, showing a stunning lack of basic firearm knowledge. But this wasn't just confusion, it was open bias. Some judges seemed unwilling to acknowledge the national ownership numbers, which are well into the tens of millions. One judge went so far as to claim that if a state like California has fewer owners, the concept of common use might not apply. That completely misses the point. Constitutional rights don't depend on your zip code. The Second Amendment isn't valid in Texas, but void in San Francisco. That's not how our rights work, and that logic is not only flawed, it's unconstitutional. This isn't just some harmless legal back and forth, it's outright defiance. Despite crystal clear rulings in Heller, Bruin, and now Smith and Wesson, certain judges are still bending over backwards to avoid the obvious. They downplay binding precedent, treat Supreme Court language as if it were casual commentary, and conveniently ignore the overwhelming statistics. It's the same old playbook: delay the process, muddy the waters, and keep the case in legal limbo. That's likely what we'll see next. Rather than issue a decision in Miller versus Bonta, the Ninth Circuit panel may choose to shelve it again, waiting on another related case, like Duncan versus Bonta, to move forward. It's a stall tactic, plain and simple. They're pretending the constitutional question is still up for debate. But it's not anymore. The highest court in the land has made itself perfectly clear. And every day, a lower court dodges. That truth is another day. The rights of American citizens are being ignored, not by statute, but by intentional judicial obstruction. This legal battle isn't just confined to the Golden State. What's happening in Miller versus Bonta, when viewed alongside the Supreme Court's unanimous ruling in Smith and Wesson, could reshape the entire national conversation around so-called assault weapon bans. If rifles like the AR-15 are recognized as being in widespread, lawful use by responsible Americans, then similar restrictions in places like Illinois, New York, and New Jersey are standing on shaky constitutional ground. Most of these state-level bans aren't based on how the rifles function, they target them based on cosmetic features. A pistol grip, a flash hider, or an adjustable stock is enough to label a perfectly legal firearm as an assault weapon. But if the courts actually apply the Second Amendment, using the standards laid out in past cases, those bans will crumble under legal scrutiny. The Smith and Wesson decision didn't just clarify a narrow legal point, it injected fresh energy into the gun rights movement. Lawsuits from coast to coast are now leaning heavily on that ruling to drive home one fundamental fact: these rifles aren't rare, they aren't exotic, and they certainly aren't beyond constitutional protection. They are common firearms, used regularly by Americans for home defense, training, hunting, and competitive shooting. In other words, they fall squarely within the Second Amendment scope. Here's where it gets tricky. While some courts will stick to the Constitution and follow precedent, others, particularly within the Ninth Circuit, are likely to drag their feet. Some judges may sidestep these rulings altogether, hoping to delay final judgment with conflicting decisions or procedural slowdowns. That tactic can create what's called a circuit split, where federal courts in different regions issue opposing rulings on the same constitutional issue. And when that happens, it often forces the Supreme Court to step in and resolve the conflict once and for all. That moment is coming, and fast. Whether the case that finally gets there is Miller, Duncan, or a new challenge from New York or Illinois, one of them is going to put assault weapon bans squarely before the Supreme Court. And when that happens, the legal foundation built in Heller, reinforced in Bruin, and now echoed in Smith and Wesson, will take center stage. It's not a question of if anymore, it's a matter of when and how decisively the court will act. This is more than just another round in the courts. It's a pivotal constitutional clash. The Supreme Court, speaking with one voice, has already confirmed what millions of law-abiding gun owners have said for years. Rifles, like the AR-15, are protected arms under the Constitution. That truth is now reverberating through federal courtrooms across the country, and laws that once seemed immune to challenge are now being exposed for what they truly are: unconstitutional infringements on the rights of everyday Americans. Some lower court judges may keep trying to kick the can down the road, but they can't stall forever. Every word in a Supreme Court ruling carries legal authority, and in Smith and Wesson, those words just handed the pro-gun community one of the most compelling legal tools in the fight for freedom. Now the only question is this: will the lower courts get back in line, or will the Supreme Court have to remind them once again what the Constitution actually says?